Chapter 6, Recordation, Abstracts, and Title Insurance. Prior to the passage of the Statute of Frauds, notice of ownership was given by possession or occupation. Post-Statute of Frauds, ownership was evidenced by the written deed. However, a problem arose as to who had the most current deed. The solution to this was via government-sponsored recording of these documents. So let's talk about public records and notice given to the world of someone's ownership. Constructive notice is notice given by the public records and by visible possession, coupled with the legal presumption that all persons are thereby notified. In other words, people record various documents related to the ownership of real estate, like deeds, to give constructive notice to the world. This is sometimes referred to as legal notice. Recording a particular document related to a parcel of real estate occurs in the parish or county where the property is located. Who can inspect these public records? Everyone. Hence, an inquiry notice means that a person interested in a property is also held by law to be responsible for making further inquiry of anyone giving visible or recorded notice. Actual notice is knowledge based on what one has seen, heard, read, or otherwise observed. In other words, a person has direct knowledge. Every state in the United States each state has its own recording acts, and that is to provide for the recording of every instrument or document by which an estate, interest, or right in land is created, transferred, or encumbered. Within each state, each county or parish has their own public recorder's office. In Louisiana, each parish has a clerk of court's office, and that is our public recorder. What's also available in the United States is the Mortgage Electronic Registration System, or MERS. It's a computerized book registration system of tracking the beneficial interests or bundle of rights connected with both real estate, both residential and commercial mortgages. So once a mortgage has been originated or created, it's then placed as a part of the public record in the county or parish it is located, where the property is located. After that, that mortgage might be bought and sold many, many times. It might be assumed several times. MERS keeps track of that on a national basis, and no additional entries are necessary into the local parish or county recorder's office. So let's take a look at the recorder's role. The Public Recorder's Office serves as a central information station for changes in rights, estates, and interests in land. Okay? So such documents as various liens, like a mechanic's lien, or perhaps a mortgage, options to purchase a property, deeds, leases, easements, land contracts may all be entered as a part of the public record to give constructive notice to the world. Who could possibly be interested in this information? Prospective buyers, lenders, and the general public at large. But some interests go unrecorded. Although recording acts permit the recording of any type of estate right or interest in land, many lesser rights are rarely recorded, especially those that have to do with leases, whether they are short-term or long-term. These types of interests are rarely recorded. Why? Because most landlords don't want the general public to know what their lease rates are, or what sorts of bargains they have struck with their tenants. However, prospective purchasers are presumed by law to have inspected both the land itself and any public records accorded to that land. They cannot feign ignorance or say, well, I didn't know. It is a party's responsibility to take a thorough look at the public record. There are various requirements for recording. For instance, for states that require witnesses, which would usually be about two, the person who's acting as a witness should know the person signing is the person named in the document. Another requirement for recording is that the document must be acknowledged. That is a formal declaration by a person signing a document that he or she did sign the document. Who is authorized to take acknowledgments? Those are notary publics. And here's an example of an acknowledgment where you can see that the signature of the notary public is down in the bottom right-hand side of this particular acknowledgment. How are public records organized? Keeping them organized is an important aspect of the real estate process and considers the following. Public records are kept chronologically, in other words, in time order. So every year, when documents are recorded, they go in chronological order. But that still might be a little hard to find certain things. Some states, only a few, about 9, have what's called tract indices. Each page in a book is devoted to a particular parcel in that county, and any document that is recorded related to that parcel is in that index for that particular tract. But there's also the grantor and the grantee indices. So each year, all grantors are listed in ABC order. Likewise, there's an index for grantees. Each year, each grantee is then listed in ABC order. We need to distinguish what a chain of title is. That's the linkage of property ownership that connects the present owner to the original source of title. In other words, it is just a listing of all the properties of a property's owners through time. Sometimes we might see a break or maybe a cloud on that title. It's very important to search other indices, not just ownership indices. Someone who is interested in a parcel of real estate should also search any judgments in case that against some of the owners there may be a judgment against. Maybe it should also examine the lis pendens index. Is there any litigation pending against that owner or that property. Should also examine birth, marriage, death certificates, any adoption records, divorce, probate, and tax records. Anything related to ownership. A chain of title is very different from an abstract. An abstract of title is a complete historical summary of all recorded documents affecting the title of a property. So it's much more than just a list of owners. It recites in chronological order all recorded grants, conveyances, recorded easements, mortgages, wills, tax liens, judgments, pending lawsuits, marriages, divorces, etc., that might affect its title. The abstractor will summarize each document. Note the book and page or other source where it was found and give the date it was recorded or entered. There are different ways that we can assess ownership proof. The first is through an opinion or certificate of title. That means an attorney renders an opinion on the quality of a property's title after reading the abstract. An alternative is title insurance. and we'll get to that in a minute. So to reiterate, title insurance, the basic principle is similar to any form of insurance. Many people pay a small amount into an insurance pool that is then available to any one of them should they suffer a loss. And again, in some parts of the United States, it's customary to purchase a title insurance policy through the attorney who reads and certifies the abstract. Elsewhere, it's custom to purchase it from a title company that combines the search and policy in one. And this is what the title commitment looks like. Back to the Torrens system. That's a system of land title registration that starts with a landowner's application for registration and the preparation of an abstract. It's followed again by a quiet title suit. In other words, determining who is the owner of the property and who has an interest, at which all parties named in the abstract and anyone else claiming a right or interest to the land in question may attend and be heard. The Torrens system is very similar to the way that we register the ownership of our automobiles. This is a very efficient system of registration, but it's also very expensive, and only about 10 states in the United States use the Torrens system. One doesn't have to search back any further than the last quiet title suit. Any subsequent liens or encumbrances must be entered onto the registrar's copy of certificate of title to give constructive notice. Again, marketable title is a title on a property that is free from reasonable doubt about who the owner is. Marketable title acts stop claims to rights or interests in land that have been inactive for longer than the required statutory period of time. Some key terms to be familiar with after reading through Chapter 6. Should you have any questions, feel free to ask.